Hi, Sam.
Hi, Mariana. So, welcome to our new series, Tea with Noli IP. Today, I'm interviewing our founder, Mariana, and she's going to be answering some questions that I have about trademarks.
Thank you, Sam. Thank you. Well, I want to share the presentation that Sam has prepared for us. And this presentation, it's going to help us go through some of the basics of trademark law. That is one of my passions. So keep calm and call your lawyer, your trademark lawyer. We're here to help you. You can always contact us if you have any questions. Sam is in charge of our digital marketing. She oversees all the Facebook, Instagram, LinkedIn accounts. Thank you, Sam, for the work that you're doing. And I'm really excited to participate in this series, Tea with Noli IP.
Okay, so my first question would be, what is a trademark?
A trademark is a word, it's a phrase, it's a slogan, it's a design, a logo that works as a source identifier of goods or services. And what that means in plain English is that when you go and buy a coffee and you buy it at Starbucks, you know that you're guaranteed to have a coffee that has certain characteristics and certain qualities. And that goes for fashion items, clothing items, perfumes, and anything like that. So when you see a brand, the trademark, it will secure that you're obtaining a certain quality of goods or a certain quality of services.
Okay, that makes sense. So, what would the difference be between a trademark and a patent?
In simple terms, a trademark works as a source identifier. As I was saying, when you go shopping and you buy a Chanel purse, you know that your purse is going to be of certain qualities and characteristics. A patent, on the other hand, it protects an invention. What is an invention? So it has to comply with several requirements of patentability. It needs to be novel. Nobody needs to have thought about it. And it has to have industrial applicability. So there are all these requirements that an invention needs to comply with to be granted patent protection. The difference between a patent and a trademark is, for example, when you buy an Apple phone, an iPhone is the brand. But there are many patents behind iPhone that protect the different features that make that phone function.
Okay, so when would the right time to get a trademark be?
Of course, I'm going to tell you to do it as soon as you found a name, a slogan, or a design that you want to use as a sort of identifier for the goods and the services that your company offers. And I say this because there are so many trademarks in the registry, you'll be surprised. It's very difficult to find names that are still available. There are thousands of businesses, and a lot of the good names, you know, may seem to be available. That's when you want to engage the services of a lawyer or a searching firm, because you want to make sure that the name that you choose, it has not been taken. So my advice is the sooner the better.
Okay, so if I was to start right now, how long does it take to get a trademark?
You know what, it takes between 12 to 18 months if there are not any hiccups, and sometimes it takes even shorter than a year. So it really depends. I highly recommend that you invest in doing a trademark search, because that gives you and gives the attorney the idea of whether the name's taken or not. So starting with a trademark search, and if it looks like it's available and your attorney gives you the green light, go ahead and try to protect and secure that name.
Okay, so once I get the trademark, how long is it good for?
You know what? It is good indefinitely. There are companies that have been doing business for over 100 years, right? You've probably gone to the parks, the Disney World and the Disneyland parks. Lego is another brand that's been around forever for those that have kids that play with these toys, and that has been a brand that was protected. And how it works, Sam, is that you obtain trademark protection, and then within the first 5 to 6 years, you have to renew your registration. And then after that, it's every 10 years. So every decade after the registration, every 10-year anniversary, you have to pay a fee and you have to file a specimen of use.
Okay, that makes sense. So, should I protect my logo or the word mark?
And then again, I'm going to tell you that you protect everything. So a lot of times you think that you're protecting the word mark and it would be enough, but then maybe your graphic designer came up with a very unique logo that it's worth protecting. And I would tell you protect that too. The reason being is that you want to have your protection in place in case there are infringers. And while your business is doing okay, maybe not other people are going to copy you, but as your business continues to succeed, a lot of people are going to try to profit and benefit from the goodwill that you have built in your business. So my opinion is, if you have a very tight budget, this is very important. Sam, let's say this is like a small business and you have a very tight budget, then probably you would start with the word mark in a standard characters because that gives you the broadest protection. But then as soon as it becomes available, try to protect your design as well. Better safe than sorry.
Yeah, those are some good tips. So, what information do I need to file a trademark?
To file a trademark, you'll need to provide the applicant's information, the address, the name, full name, and the citizenship. You also will need to select the mark that you're going to be using in connection with what goods or services you're going to be using it. For example, today I had a call with a client friend and she has a company and she does not only manufactures clothes under this brand, but she also has online stores. So I recommended her that she protected under class 25 for clothing, under class 35 for online retail services. And, you know, that way you have the most protection. You will also need to provide information on the use because the United States requires the mark to be in use in commerce. You will need to provide a specimen and you will need to provide the dates of first use.
Okay. So, what are the costs for protecting my trademark?
You know, the official fees with the government, the filing fee, ranges somewhere from $275 to $375. Here at Noli IP, we have a starters package that we charge $1,200 for the straight registration, which means that there are no substantive office actions, such as likelihood of confusion. Did I answer your question?
Yeah.
Great.
Okay. So, what happens if someone else uses my trademark? And
and I guess everything that I've been telling you about, like to protect your word and your logo and protecting the classes that you're actually doing business, not just in the main class, it's because you want to be protected from this, from if the opportunity happens where people start taking advantage of the goodwill that you have built in your business and they go after and try to use some trademark that is similar to yours. This process of enforcing your trademark rights can be very costly, but we also have some flat fee packages that, depending on what it needs to be done, if it is sending a cease and desist to an infringer to make them stop, that we can charge $700. So I highly encourage you that if you get a cease and desist, or if you know of other companies that are using trademarks that are similar to yours, that you contact us immediately and we'll be able to work with you.
okay, that sounds good. Thank you for answering all my questions.
Thank you, Sam, and I hope you have a great day.
You too.
Bye.
Bye.